building upon the principle of dealing fairly with all parties. It is equally vital for Arizona real estate licensees to understand and manage conflicts of interest that arise when they have a personal or financial stake in a transaction. The Arizona Department of Real Estate, ADRE, through the Commissioner's Rules and ARS Title 32, Chapter 20, has long recognized that a licensee's ability to remain objective and loyal to their client can be compromised when self-interest interferes. Therefore, full disclosure, transparency, and strict adherence to fiduciary obligations are required whenever a potential or actual conflict of interest exists. A conflict of interest occurs when a licensee's personal, financial, or professional interests could interfere with their duty to act solely in the client's best interest. The foundation for managing these conflicts is found in Commissioner's Rule R4-28-1101A, which requires every licensee to protect and promote the interests of the client while dealing fairly with all parties. This rule underscores that even the perception of a conflict can harm public trust and violate professional ethics. Similarly, ARS Section 32-2153A3 allows the Commissioner to suspend or revoke a license for conduct that is dishonest, negligent, or untrustworthy, all of which can stem from undisclosed conflicts. Conflicts of interest can take many forms in real estate transactions. A common scenario is when a licensee acts as both the agent and the principal, meaning they have an ownership or financial interest in the property being bought or sold. For example, if a licensee owns an investment property they intend to sell, and a client expresses interest in purchasing it, the agent must disclose this ownership interest in writing and in advance of any offer being made. Failing to do so could be viewed as self-dealing or concealment of material facts, violating both R4-28-1101E and the duty of loyalty. Similarly, when a licensee seeks to purchase a property listed with their own brokerage, they must notify the seller in writing that they are a licensed real estate professional and that they may personally benefit from the transaction. This requirement exists to prevent unfair advantage, as licensees typically possess greater knowledge of market conditions, negotiation strategies, and property disclosures than the average consumer. Arizona courts have consistently ruled that non-disclosure of such self-interest can amount to fraud or misrepresentation. In Baker v. Stewart Title and Trust of Phoenix, Inc., 1978, the Arizona Court of Appeals reaffirmed that a fiduciary's failure to disclose material information affecting their personal gain constitutes a breach of trust. Consider a practical example. A licensee working with a first-time homebuyer learns about a distressed property listed below market value. Seeing an investment opportunity, the licensee writes an offer through a family member's name without disclosing their connection to the buyer. This behavior violates ARS Section 322153A3 and R42-81101E because it conceals self-interest and undermines fair dealing. The proper course would be for the licensee to disclose in writing to the seller that they have an indirect financial interest in the purchase, and to ensure that the seller acknowledges this disclosure before accepting any offer. Transparency eliminates suspicion and preserves integrity. Conflicts also arise when a licensee stands to receive dual compensation without disclosure. For instance, a licensee may earn a sales commission from a transaction while simultaneously collecting referral fees or bonuses from a third party, such as a title company or builder. Under ARS Section 32-2153A22, receiving or offering any form of compensation without full disclosure to all parties is prohibited. Failure to disclose such arrangements could lead to disciplinary action and potential loss of license. In addition to legal requirements, professional ethics emphasize self-awareness and avoidance of even the appearance of impropriety. The National Association of Realtors Code of Ethics, Article 4, mirrors Arizona law, by requiring that realtors shall make their true position or interest known when buying or selling for themselves, their family, or their firm. Arizona law aligns with this principle to ensure that clients are never misled or placed in a disadvantageous position due to an agent's undisclosed self-interest. When self-interest cannot be eliminated, the licensee's best protection is full written disclosure and client consent. Under R4-28-1101E, any material relationship or interest that may affect a client's decision must be communicated in writing before proceeding with the transaction. This gives the client the opportunity to make an informed decision and preserves the licensee's compliance with the duty of loyalty. If a client does not consent, the licensee must withdraw from representation to avoid a direct conflict. There are also situations where conflicts are unavoidable but manageable through transparency and supervision. For example, a designated broker may have ownership in the brokerage that represents both buyer and seller. While this inherently creates potential conflicts, it is permissible, so long as both clients have provided written consent to limited representation under R4-28-1101F, and the broker ensures fair and equal treatment to both parties. The ADRE views conflicts of interest as serious ethical and legal violations because they undermine consumer trust, the cornerstone of the profession. Licensees who fail to disclose self-interest or act on conflicting motives risk penalties, including fines, license suspension, or permanent revocation. More importantly, such conduct can permanently damage reputations and client relationships. Review summary. Conflicts of interest occur when a licensee's personal or financial motives interfere with their duty to act in the client's best interest. Arizona law. Through R4-28-1101A and ARS Section 32-2153A3 mandates that all such interest be disclosed in writing before any transaction occurs. Whether the licensee is buying, selling, or receiving undisclosed compensation, transparency is essential. Cases like Baker v. Stewart, Title and Trust highlight that failing to disclose personal gain constitutes a breach of fiduciary duty. The best protection for any licensee is early disclosure, informed client consent, and professional supervision by the designated broker. Discussion. Why is disclosure of a licensee's ownership interest in a transaction critical? Answer. Because it ensures transparency, protects the client from potential bias, and maintains compliance with R4-28-1101BF and ARS Section 32-2153A3. What must a licensee do if they wish to buy or sell a property in which they have an interest? Answer. They must disclose in writing that they are a licensed real estate professional and obtain written acknowledgement from the other party before proceeding. How can a licensee manage an unavoidable conflict of interest ethically? Answer. By providing full written disclosure, obtaining informed consent, and ensuring fair treatment to all parties under R4-28-1101E and R4-28-1101F. Closing remarks. Integrity in real estate is built on transparency and trust. When a licensee's self-interest intersects with client representation, disclosure is not merely courteous. It is legally required. Conflicts of interest test the professional ethics of every agent, demanding honesty and accountability. By disclosing, documenting, and managing conflicts proactively, licensees protect not only their clients, but also their professional credibility and the public's trust in Arizona's real estate industry.